Hi, I'm Liam Tobin. I'm an associate at Baker Love Lawyers, here to talk to you today about informal wills. When a loved one passes away, it's not uncommon to find that they've left behind a will that they've prepared themselves, which outlines their wishes. Now, those left behind face a problem where that document doesn't comply with the strict formal requirements for a valid will as set out in the Succession Act of New South Wales. The Act does allow for the Supreme Court to look at evidence relating to the preparation of the informal document to determine whether the court is satisfied that the document was intended by the will maker to become their new will. However, this shouldn't be taken as a reason to just throw together a document at home, as recent cases have shown that it isn't always easy to convince the court to accept an informal will or even to anticipate their decision. The Victorian Supreme Court recently made an interesting finding in the matter of Sultanova and Bulgaro that an informal document was intended to be the last will of the deceased. In this case, the document was prepared by a solicitor with its contents then summarised over the phone to the client. The client then replied that it was exactly what she wanted and that it was settled. Unfortunately, the client passed away before the document was signed or even seen or read in full, but it was still found to embody their wishes as an informal will. Now, the Supreme Court of New South Wales recently took a very different view to very similar facts regarding the estate of Missouri. Similarly, the client gave instructions to their solicitor for what they wanted in their will, and that document was prepared. The client then had to cancel their appointment to sign the document due to illness, and unfortunately passed away before signing the document. In this case, the court wasn't convinced that the instructions to prepare the document or the unsuccessful attempts to sign the document proved an intention to adopt that document as their final will. These very different decisions on similar facts show that it can be difficult to be certain whether the court will find that a document should be treated as an informal will if it fails to comply with the Act. Any uncertainty can be avoided by getting proper legal advice and guidance to review your current will or prepare a document that properly takes care of your wishes. For assistance, contact Baker Love Lawyers.